Let's take a look at this fact pattern written in a multiple option question. So it says, Bert wrote Carl saying, please ship 200 Model Y bicycles per your published price. Carl shipped 200 Model X bicycles, which are the predecessors to Model Y, but are not outwardly different. What action did Carl accomplish with his actions? Well, here we have a situation where someone is asking for 200 bicycles and the person contacted can respond with 200 bicycles. Given those quantities of products, we can assume that these are merchants, and so we will apply the UCC Article 2, Uniform Commercial Code Article 2, and we see graphically that the situation is shown here as between merchants, and the way that an offer can be accepted, different combinations of offer and acceptance. We see here the appropriate diagram for the UCC Article 2. We know that initially there was an offer, an express offer to buy 200 bicycles, and then we have to figure out what happened afterwards. In certain situations there can be acceptance and possible breach, or there could be a counter offer. So we look at the options, and it says A, the formation of a bilateral contract. Could there have been the formation of a bilateral contract? Well, in order to form a bilateral contract, there need to have been express acceptance. That is, there need to have been clearly spoken or written manifestation of acceptance of the offer, and then it would have been a sort of a negotiated bilateral contract, and in verbal or written form, and it probably would have included a promise to ship and not an actual shipment. So we are not on this topmost branch of the tree. We will look at the next option. B, it says acceptance of Bert's offer and breach of contract. So this looks highly probable because Carl shipped very similar bicycles. Carl did not negotiate. Carl simply shipped, and therefore is acting acting on the unilateral contract of Bert. And the fact that the bicycles are very similar indicates that there's some breach here, whether it be minor or major, can be debated. But the Carl's shipment was acceptance, and that looks like a very good option at this point. Option C says meeting of the minds. And meeting of the minds is the common law theory that with their intents and their actions, the two negotiators or the two parties are coming to a concurrence or a synchronization of their mutual intent or mutually agreed upon actions to follow. However, in this case, we see no discourse, we see no dialogue between the two parties, and so meeting of the minds is an unlikely option, incorrect option. Option D says counter offer. Did Carl accomplish a counter offer with his actions? Well, we see here that a counter offer on the bottom branch, it splits into two here. A counter offer is either an express counter offer, which in this case was certainly not made. Carl did not express, either in spoken or written form, a different offer that he put back to Bert, and so a counter offer did not occur. And the last option asks if Carl accomplished an accommodation or a request for an accommodation by shipping slightly different goods. And we see here in the tree that accommodation, the nuance in accommodation is that notice of an accommodation is needed. That is, notice of a provision of slightly different goods, and questioning as to whether the recipient of the goods will accept those as a suitable shipment or a set of products. And then, of course, it's at the buyer's option to either accept or reject the whole when under an accommodation. So under these possibilities within the Uniform Commercial Code, we see that what has happened here is that Carl, by shipping goods that are outwardly similar to the goods requested, Carl has accomplished an acceptance by his shipment and is acting on this unilateral contract that has not been that is not a bilateral contract or negotiated on both sides. However, Carl has also breached the contract by shipping goods which are not those requested or acceptable to the purchaser, Bert. So this is the situation. This is Eric Smith with the Graphical Approach to Law.